Welcome back. Thank you for staying with us. Now, the moment Kenyans had been waiting for eagerly finally came to pass with the apex court in the land rendering a verdict on the disputed presidential election. The court upheld the victory of Dr. William Ruto, as was declared by the chairman of the Electoral Commission, Wafula Chebukati. The pronouncement by the seven-judge bench of the Supreme Court certainly have implications to the Kenyan political arena, which we seek to find out tonight. Joining me for the discussion is Wakili Joseph Karanja, an advocate of the High Court, and Kennedy Sankara, a political commentator. Thank you so much, gentlemen, for dedicating your time for this discussion. And probably we'll start with you, Sankara. What do you make of the verdict that was rendered by the Supreme Court today?
Well, thank you. The verdict brought clarity. You know, until the time of the verdict, most of Kenyans, based on Julie Soweto's submissions, believed that William Ruto was elected by Jose Camargo in Venezuela.
Right.
But those allegations have been thwarted by the Supreme Court judgment or verdict, and the official position is that he was elected by the people of Kenya in 8 August.
Right.
Majority of Kenyans may disagree with the Supreme Court verdict, but they've promised to respect it.
Right.
So we have implications, definitely, but that's the official position we are today.
All right. Wakili, we saw your fellow learned friends, of course, at the Supreme Court, and we saw that, of course, even when they were filing the petition, we saw a lorry coming full of evidence that they would present before the seven-judge bench, and I mean, the court overturned everything that they were presenting in their petition. So from a legal point of view, what do you make of the ruling that was made by the apex court on the land?
Thank you, Ken, and thank you for having me. First of all, let me say this blue suit has no affiliation to any political side, be it Azivio or UDA. Today, we witnessed the maturity of our judiciary. The lorry, in fact, was delivered, yes, and it had a lot of documents. But like my colleague has said, my learned colleague, Julie Soweto, did a fantastic job. Unfortunately, her evidence did not meet the threshold that has been set all through the petition since 2013. And it must be remembered that the basis for which a presidential election is either nullified or allowed is purely provided for in the Constitution.
Right.
So it's either your evidence meets the threshold or it doesn't meet. There is no middle ground. Yes.
All right, Sankara, maybe we go back to you because you are an ardent supporter of the Azimio camp. When they lost, the Azimio lost the presidential election, there were allegations that there were electoral malpractices in these 2022 general elections that could probably amount to nullification of the presidential results. So the expectations that the Azimio had in this 2022 general election, do you think the expectations that the Supreme Court rendered in the verdict were met, of course, by these, by the court?
Well, in their own wisdom, the Supreme Court ordered for 2 specific activities: a recount and also access to servers for verification of the uploaded Form 34As and nitty-gritties that happens with the servers. We had the oral submissions from the Azimio Brigade in the courts, but being that this is a matter that has been decided, that also does not prevent me from prosecuting in the court of public opinion. The Azimio claimed that there were involvement, illegal access, interference, and that's why I was specific in my quotation that Julie Soweto claimed that William Ruto was elected in Venezuela by Jose Camargo because there were trails of Jose Camargo form 34A that was uploaded in the system. So basically scrutinizing all these things, the burden of proof lies with the respondents, not the petitioners. They made an official allegation. Now it was upon the respondents to prove that did not exactly take place in the process. We saw the rebuttal, the submissions, to a reasonable percentage, the evidence was there. And if I'm not wrong, the Supreme Court said the evidence they provided, yes, but it was insufficient in their own eyes and wisdom. So definitely that do not strike out possibility of Azimio having defended their allegations to their ability. The only mismatch is their defense did not meet the threshold as quoted by the judges. So it leaves the Azimio with the position, and the official leader has spoken. He has said he respects the court verdict in as much as he disagrees with it, which is his constitutional right.
All right.
Yes.
All right, Wakili, maybe just to get an insight from you, because we understand that in the affidavits that was sworn by the petitioners and in the evidences that they were tabling before the 7-judge bench, we understand that at some point the Supreme Court Chief Justice, that is Martha Koome, said that there was misconduct by some of the advocates by swearing affidavits that were bearing falsehoods. And of course, probably after this verdict was rendered, we saw Senior Counsel James Orengo saying that the verdict was ideological and a mistake on the part of the court. So, in the submissions of the petitioners and during the rejoinder, we saw the points that they were arguing on. This issue that emerged, that there was falsehood in, the advocates swearing in swearing affidavits that are bearing falsehood. So, the great rejoinder that we are seeing here at the Supreme Court in this petition, was it that they didn't have any form of evidence, or is it that only that the evidence didn't meet the constitutional threshold to probably satisfy what they had in mind? Of course, that was the nullification of this presidential election.
What the judges said, actually, it's not the lawyers who did the affidavits. It is the deponents of those affidavits. One of them was by the famous John Mark Kidongo, where he attached logs from the 2017 general elections, and which were discovered in the response by the IEBC. He swore a fresh affidavit, and in that fresh affidavit, he totally vacated the previous affidavit that had the contested logs. And the question the judges were posing to the advocates, who are very well decorated, who represented the petitioner and who did a fantastic job in their presentation of the evidence, was that how could you allow your clients to swear affidavits through hearsay? John Gidongo was telling us that he met in some place in Karen with a young man who had a laptop, who told him that forms were being captured from the sky and modified. And through the whole hearing, the judges kept on asking, how is it possible that a form that traveled by air was captured in the air and changed, whereas the one that traveled by road never changed?
Right.
Counsel Julie Soweto did a good job and presented that form that had a marking on the top where the name of the famous Joseph Kamago appeared, but the hard copy form did not have that document. It did not have that background of Kamago, and that is why the court was saying the evidence may sound like it is very big now that it was brought by a truck, but it all ended up being hot air. It did not meet the threshold, which is above the balance of probabilities, but not beyond a reasonable doubt. So it might look like, when it's in the public, it might look like it actual sense Dr. William Ruto was elected in Venezuela. But the report that was made by the Registrar of the Judiciary after the servers were opened, after the scrutiny was done of all the polling stations requested by the petitioner, it turned out that there was no discrepancy between what the IEBC had announced and what the hard copy documents actually showed. Yes.
All right, maybe Wakili, maybe the other thing do you wish that you emphasize for us, because Senior Counsel Orengo was saying that the verdict was ideological and a mistake on the part of the court, and even Kalonzo Musyoka, of course, he also a lawyer, saying that even though I do not agree, but I respect the decision of the court. So the counsels that were representing the petitioners, where exactly are they finding fault on the Supreme Court in the verdict that was rendered today?
Let us remember these are the same team of advocates who filed Raila 1 in 2017 and succeeded on the very, very same test that they have failed this time round. One, Wafula Chebukati conducted this election in the manner, style, and fashion he was directed by the Maraga judgment in Raila 1 in 2017. And the parting shot of CJ Emeritus Maraga said, if you do not fix the irregularities that I have mentioned, I will once again nullify the elections. So Wafula went out and fixed the irregularities in the law, in the regulations, and conducted the elections in accordance with the Constitution. The burden of proving that the elections was so badly done that it could not stand the test of the Constitution was on Orengo and his team. They failed to satisfy the judge. They cannot then come back and complain that the judges rendered an ideological decision while it was based on the evidence and facts that they presented to the court.
All right. Sankara, maybe the other thing that probably, of course, I would want to get from you, because what the Azimio team was anticipating in filing this petition is that there are a lot of malpractices in the electoral process that could sufficiently mount to nullification of the presidential election. But the Supreme Court has ruled otherwise. So what does this tell us? The kind of things that were emerging, the kind of things that were emanating in the Supreme Court when the Azimio team were making their submissions, terming them, of course, alleging that these were now the electoral malpractices. So should Kenyans just give it a blind eye, saying that everything was done constitutionally? The Electoral Commission conducted this election as anticipated by the Constitution.
First, before I respond, allow me to say Jose Kamago is not famous in Kenya because he has been trending not for the good deeds or allegations. The allegations that have been made against him are so grave for a patriot like myself to say Jose Kamago is famous. Maybe he's famous online in Venezuela. It is not in order for us to say that the elections was 100% perfect. Remember, that's why the judges quoted that the evidence were presented, but they were not insufficient. Election is not an event; it's a process. And I would quote the words of CJ Emeritus, David Maraga. He said, "Elections are not events; they are processes that take time, and the process must fall within the constitutional expectations." Personally, I've raised questions. It is in the public domain that I'm not having the first conversation on IEBC. I've done it severally, almost 2 years even before these elections were conducted. And I was categorically speaking on the preparedness of IEBC to handle a free, fair, verifiable presidential or general elections. It was categorical that there were some loopholes here and there that would sabotage the constitutional expectation of a free and fair elections. So as one who actively participated in the electoral process, it will be a big lie to tell myself and convince other fellow Kenyans that the elections were freely and fairly conducted. And that's why we refer to the verdict and say we respect the verdict, but we do not agree with it. I think we're still communicating. So the disagreement emanates from the dissatisfaction that originated from the visibly presented malpractices that might have been witnessed. But again, they may not have equally constituted to a nullification or the weight was not that much, but that does not rule the element of malpractices here and there. They were. The demonstrations, I'm just referring to the demonstrations that were done by the Azimio la Umoja One Kenya Coalition legal team, which the court termed as hot hair. So I can't rule that there were no malpractices. There were inconsistencies. I had even said it myself here that people who were constitutionally mandated to oversee the smooth running of elections did not have the knowledge to tell or to know what to be done when and how. That, I mean, I saw it when I went for my voting exercise in Kileleshwa. So these are things that happened. They actually happened, but maybe the scope of the court is that in as much as they were there, and in reference to previous jurisdictions, there were reduced elements of inconsistencies that arise from IBC. But I would reiterate that election is a process. In procurement, we are told it is not about the product, it is about the process. So you can't garbage in, I mean, you can't feed in wrong information and expect, you can't feed in wrong data and expect the right information. It's garbage in, garbage out. You key in wrong information, you get the wrong result. So the output must be equivalent to what you gave out. So the IBC might have failed, and I believe they have learned, because we Kenyan judicial system, nullifying a presidential election is not a new thing. They will definitely do, because they don't do so to please some politicians or the political classes, but they do so to reaffirm the sovereignty of the people of Kenya and the supremacy of the Constitution, which is the guiding document on conducting elections generally.
All right. Now, Wakili, because there were a lot of references being made to the 2013 general elections. Of course, now that was being termed as Raila one, the cases that the judges were referring to. So we saw that from the contested, rather from the disputed previous elections that was nullified, they were making references to it. And of course, through the nullification of the elections, we saw a number of reinforcements being made to the electoral commissions, which probably amounted to what was to be considered rather to be a free, fair and credible elections in this 2022 general election. So in as much as, yes, the needs and the desires of the petitioners were not met in the judgment that was made today, but what do you make of it? What do you make of this petition that was made by Raila Odinga and of course Martha Karua, trying to say that there were electoral malpractices, and of course probably should Kenyans give it a blind eye and focus on the next 5 years, and probably when the next general elections will be held, we go without fixing these issues that were emanating in these 2022 general elections?
First of all, we as Kenyans owe it to one Right Honorable Raila Odinga for the many great improvements he has done to our electoral laws, starting with the Cregler Commission in the year 2007.
Right.
The benefits of the elections that we did on the 9th of August, and the following day Kenyans woke up and went back to work, can only be credited to the many efforts, either in the forefront or behind the scenes, directly or indirectly engineered by the Right Honorable Prime Minister. What stood out between the 2013 petition all the way to this petition was one case by the one that was done through the civil society, formerly popularly known as the Maina Kiai decision, which at the end determined that presidential election ends at the polling station. And during the rebuttal by Mahat Somane, the advocate for IEBC, he proved to the court that not a single Form 34A had been altered in the server that was not consistent with the hard copy documents that the IEBC had provided certified copies to the court. And under Article 138, what Chebukati uses or used as required by law to declare the results of the president-elect or the results of the elections, presidential elections that is the hard copy document.
Right.
Remember, out of the over 49,000 polling stations, those Form 34As are filled in handwriting. You know, as a reason, as a precipitate for security features, so that when you had the learned judge Smokin Wanjala asking, how come the form that was being traveling by air was captured as the petitioners alleged, but the one that traveled by road was not captured?
Right.
When the judges said the evidence was hot air, they did not just dismiss that evidence. All they said is, do not bring hearsay to the court. And they appreciate that the elections, IEBC is not an individual, it is an organization, and it is handled, and the process is handled by human beings. So we are bound to have errors. And unfortunately, there is a principle of law that says de minimis non curex lex, that of small things, the law knows no cure. And maybe that is why, as much as the Azimio team feels that their evidence was so huge, and that the outcome that the court has given out of the 9 issues, none of them passed the threshold, the buck still stopped with them. It was not for quote-unquote IEBC to prove that they conducted the election in accordance with the constitution. It was for the petitioners to prove that the election was so badly conducted that it could not stand the test, which they failed to do in this instance. But we await the reasoned judgment within 21 days. We can make further allegations and further findings based on that reasoned judgment.
All right. Well, on that, because the Supreme Court Judge Martha Koome said that Kenya should be waiting for a comprehensive judgment on the 21st. Should we expect anything different from what we saw today?
It will not be substantially different, but it will have reasons. Today they read to us their findings. They did not give us what is called the ratio decidendi, the reasons behind the findings, which is what they will be giving us. And that is how they will be showing the so-called hot air, or how the evidence failed to qualify the test that has been set through Raila 1 in 2013 and Raila 2 and the other petition in 2017. Yes.
All right. Sankara, the leaders allied to the Azimio team, they have said that they respect the decision of the Supreme Court in as much as, yes, they do not agree. But from what the ground is saying, have they accepted and do they agree with the decision of the Supreme Court?
You know, respecting constitutional, Supreme Court verdict is just running away from the legal ramifications that may come with disobeying it.
Right.
But disagreeing with it, that is a constitutional right. You can disagree respectfully. So definitely they haven't accepted the outcome, but they respect it.
Right.
So any actions they are going to take, I believe, will be in the good faith for our progressive development as a country in the socio-political spheres. And again, let me just say something. You know, I'm a young person and I interact with information, not hearsay. It's sad at this particular point in time, considering the thresholds on which IBC declared Dr. William Ruto President-elect, he got a vote of 7 million, Right Honorable Raila Odinga got 6 million. It is very wrong for Kenyans or fellow Kenyans or political leaders to spread the propaganda and mock the people from the other side. You know, you can let people lose but do not rob them their dignity.
Right.
A person of the stature of Raila Odinga does not qualify to be drawn or painted in a wheelbarrow being pushed to Bondo. Raila, my learned friend has just told you that we owe it all to Raila.
Sure.
Most of the things that we are doing today, Raila has been championing for strengthened institutions and not individuals. And that's when the Supreme Court makes reference to previous jurisdictions on same matters brought before it by the same person, that automatically communicates a simple message that Raila wants a working system. So briefly, it is unfair for a millennial generation to draw a portrait of Raila in a wheelbarrow and spread it all over social media that is being taken to Bondo. How now? This man has spent all his lifetime fighting for institutional correctness, something that we find amiss in our country. In institutional correctness. This is what Raila has been fighting for. It is not in order for young people or political leaders to, at this particular point in time, to perpetuate such like conversations. It is a time to let those who lost have their dignity, they retain their dignity, they heal over this process, because at the end of the day, Kenya is bigger than Raila and Ruto. We need to move on, but we cannot move on when we keep on having antagonistic thoughts and actions. I think that is demeaning, and as a patriotic citizen, I don't think I will allow that or take it lightly. It's a caution that people must learn to create boundaries. There are people you can belittle, and there are people you cannot belittle. First of all, running for a presidential election, winning a presidential petition in the Supreme Court, failing to win, those are not just mere achievements. They are great achievements, because the next elections to be conducted, the commission in charge will strictly adhere with the verdict or the provisions or guidelines that will be given based on the observations that were made or loopholes were made in this election. So we cannot utterly say Raila is less important in our country or political dispensation. No, that is very wrong. We must shun and desist.
All right. Now, probably as we end up, Wakili, we are seeing, of course, a government coming into play, but the win was a very slim win, because if Ruto had 50 point from some decimals, and of course Raila Odinga with, it was a very small margin of win for Dr. William Ruto. And now, looking at the government that we are going to get into, the new leadership of William Ruto and of course his deputy Rigathi Gachagua, what future are Kenyans staring at?
Well, during the campaigns they ran, they made a lot of promises. Actually, I am waiting to see how much of those promises they will deliver. They may have thought they would wink at us as Kenyans by telling us things they will do that they know they won't do. But the jury has been out as far as this election is concerned, and Kenyans have shown if you don't deliver, you will go.
Right.
There is no guarantee that Dr. William Samoei Ruto will be elected after the 5 years. He has a very huge task ahead of himself. He has to unite Kenya. The 6 million who voted for Raila Odinga are also Kenyans, and like you heard him say today, the majority will have their way, but the minority will still have to have their say. Maybe it's a time we have a conversation that the position of the official leader of opposition is enshrined in our constitution, so that we have a permanent position for checks and balances of the executive. And I welcome his idea of no handshakes. We need to have an opposition that checks the operations of government.
Right.
We don't want to have a one-sided government like the last government we've had of Uhuru and, I don't know whether to say Raila and Ruto or Uhuru and Raila alone. That hybrid setup, we do not want it again.
Right.
Yes.
Okay. Maybe just for the interest of time, Sankara, I say probably you had something to add on this here, but my director is telling me we need to do a story here. We hold on to what we have probably for another discussion tomorrow. So.